From Georgia.
Thank you, Mr. Speaker. My amendment ensures that the draconian class action rules created by H.R. 985 do not apply to cases alleging fraud. Corporate malfeasance and fraudulent practices are an ongoing problem facing American consumers. We saw this firsthand with the recent Wells Fargo case. In response to the company creating over 2 million phony bank and credit card accounts, thousands of account holders certified as a class to hold Wells Fargo accountable in court. However, under H.R. 985's new requirements, this class action would have been stopped dead in its tracks at the certification phase. This is because the bill does not clearly define exactly how similar the scope and how similar the type of injury a class member must suffer. Since each individual Wells Fargo account holder endured varying degrees of financial harm from the company's unauthorized actions, it is unclear if the victims would be considered a class under the new rules. The Volkswagen Dieselgate scandal is another example of a fraud case that would be at risk under these new rules. The German company defrauded thousands of consumers by selling cars that did not meet EPA emission standards. The cars were fitted with illegal defeat software, which allowed them to pass routine emissions tests while still producing up to 35 times the legal limits of nitrogen oxide. A new MIT study found that the excess emissions generated by these cars between 2008 and 2015 will cause 1,200 premature deaths in Europe and 60 in the United States. This is in addition to the thousands of consumers who faced financial loss because they owned these defective vehicles that they could not trade in or sell. As part of the class action settlement, consumers were able to recoup their losses through a buyback program. As currently drafted, H.R. 985 would have made such a settlement unlikely because of the restrictions on cases involving financial injuries. Finally, we have the notorious and infamous Trump University class action. Class certification was granted for the thousands of students who were hurt by the president's allegedly fraudulent for-profit scheme. Over 7,000 students were eligible for the class action because they were cheated into thinking they would become the next big real estate mogul. Instead, students lost thousands of dollars and wasted valuable time at this joke of a school. To avoid any admission of wrongdoing or face an embarrassing trial, the president and the now defunct Trump University opted for a $25 million settlement. Because of the impossible certification requirements in H.R. 985, it's safe to assume that Trump University's lawyers would have had a field day dismantling this class action at the very beginning of the litigation. Earlier this week, it was reported in the New York Times that one of the students is opting out of the settlement, and if this bill passes, the risk will be that the class action could fall apart to the benefit of President Trump. Knowing how litigious our president is, this outcome is highly likely, as H.R. 985 applies not just to future cases, but suspiciously pending as well, an almost unheard of clause to include in legislation. We cannot allow corporations, whether foreign or domestic, whether controlled by an unnamed board or by the President of the United States, to defraud consumers without facing accountability. My amendment looks to protect Americans in such cases and allows them to move forward in the courts as part of a class action. I ask my colleagues to support my amendment. I thank the Speaker, and I yield back.
The gentleman yields back.
Well, I actually reserve the balance of my time.
The gentleman reserves the balance.